Sam Seder, Emma Vigeland on the Majority Report. Want to welcome to the program, or welcome back to the program, Professor Randall Eliason, a white-collar crime professor at GW Law School and author of the Sidebars newsletter. We'll put a link to that, obviously, in our podcast and YouTube description. Professor, welcome to the program.
Thank you. Glad to be here.
So the jury starts deliberating today. I've read what you thought the defense's closing arguments should be. And they centered around basically two what you perceived as fundamental flaws in the prosecution's arguments. The first being that the prosecution hadn't necessarily proved that that Donald Trump knew that the payments to Cohen were actually not for legal expenses. And the second being that it wasn't, he wasn't necessarily, if you assume that he was actually knew that he was lying about that he wasn't lying about what he perceived to be a crime. Did I articulate that right? And if so, could you just walk us through that and elaborate and then compare that to what they actually argued?
Yeah, basically, I mean, I think fundamental flaws in terms of the defense argument, not necessarily that I would agree that they're fundamental flaws, but I think the defense's strongest argument was based on a lack of proof of intent, a reasonable doubt defense about whether the government had actually shown that Trump himself knew these records were false and caused them to be made with an intent to defraud and to commit another crime. Because I think the defense could have put on a much more effective case if they had simply said, look, you can assume the hush money happened. You can assume sex with Stormy Daniels happened. You can assume we paid Cohen back and it was all reimbursement. Mr. Trump disagrees with all that, but you can assume all that's true. But the government, the charges here are that Mr. Trump himself caused these false documents to be made, knowing they were false, and did it with an intent to cover up another crime. And that's where the evidence has fallen short. I think that was the defense's strongest case, because then it really comes down to Michael Cohen's credibility. And they spent a lot of time hammering on that, of course, which was understandable. But if they had been willing to take all the other stuff out of the case and just really hone in on, look, there's really reasonable doubt here. Is it really false to say, if I'm paying back my lawyer, that that's a legal expense? You know, when I put that in my bookkeeping, is that really criminally false? Does it really matter if there was a retainer or not? I mean, he was on the staff as an attorney. What difference does it make whether we call it a retainer? And was there really evidence that Trump himself focused on details like how is this being entered in the ledgers of the Trump organization? He's got accountants. He's got people that do stuff like that for him. So you can accept the hush money scheme and that it was sleazy and inappropriate, maybe violated some other laws, but he's not charged with those laws. You know, Cohen pleaded guilty to it. But in terms of these actual charges, the defense their best argument was that the proof fell short of showing that Trump himself knew about the false records. So that was my argument about what their best defense would be. But as I also kind of predicted in that piece, they didn't do that, because the actual defense was kind of pure Trump. So everybody else is lying. They're all out to get me. I'm a victim. And I've got to send my lawyers in to destroy Michael Cohen and Stormy Daniels, and spend a lot of time, you know, even though the defense said in their openings, Stormy Daniels' testimony doesn't really matter, which is right. I mean, it doesn't really matter whether the sex happened or not. So they said she didn't really matter. Then they kept her on the stand for hours in an ineffective cross-examination that only highlighted the kind of salacious details of the relationship. So I think, you know, whether it was because their client made them, or whether it was, you know, their own tactical choice, I think the defense would have had a much better shot with a really sharply focused, reasonable doubt argument, putting aside all the other hush money allegations and things like that. And they didn't really do that, and they didn't really do it in closing.
And just getting back to their best case that they could have presented, that first element about the retainer question. But why would Michael Cohen even perceive it as something for him to do as an attorney to pay off hush money to someone if he's not directed to do it? I mean, do attorneys, I imagine when he gets hired, right, as a retained lawyer, as a counsel, of counsel, Trump's not going like, and also incidentally, you obviously handle any type of lawsuits we get and this and that. And also you pay off all of my paramours, but make sure you do that 10 years after the fact. Like that to me seems like a weird instruct. I mean, if you're going to put an attorney on a retainer, I can understand that, but it's like, there would have had to have been some type of notion that the attorney knew this was in his purview.
And they also paid him more than what his basically fees would have been, right? And essentially to get to pay him back for paying taxes on those payments as well, which also highlighted the unusuality of the situation.
Well, that I can understand it. Like if I hire an attorney to like incorporate me and they front the money, I'd pay him back. But I've asked him to incorporate me. How does Michael Cohen come up with the idea that this is the person I'm going to pay off?
No, the whole fronting money thing is, as you noted, I mean, extremely unusual. It's not really what lawyers do. I mean, his best argument would be it was a contract. It was a legal contract at the time, putting aside whether it's possible campaign violation. And so he was, helping his client by advancing the money to pay the contract, expecting to get reimbursed, but it's certainly not typical and not something that you do pursuant to a retainer. But that's kind of my point. I mean, the defense argument that, this really was a retainer, these were legitimate legal expenses, we weren't really reimbursing Cohen for the hush money payment, just wasn't credible. It was not credible at all, especially when Trump himself is on the record saying it was a reimbursement. He tweeted about it in 2018 that they had reimbursed Cohen for these payments. And his own lawyer said it in one of the E. Jean Carroll lawsuits, I think it was, where they characterized them as reimbursements. So it wasn't credible to try to argue these were for legitimate legal expenses. What I think would have had a better shot is to say, okay, yeah, it was to pay him back for this and other expenses. So we called our payments to him to reimburse him a legal expense.
Okay,
is that really
the idea is,
so the idea it was a legal expense, it was a payment to my lawyer, right? Yeah.
So and then the retainer. The how you named it in the ledger is really just like, how else would you refer to it?
Yeah, and what difference does it make whether there was a retainer or not? I mean, again, they've got to prove intent to defraud. It's not just a technicality that this maybe wasn't technically true. I mean, we're talking about a felony here, or a crime. They've got to prove intent to defraud. Who's defrauded by whether you call it a retainer in your own internal documents that no one else has a right to see? I mean, that kind of argument, I think, would have given them a much better shot of convincing at least one or two jurors to say, there's a reasonable doubt here about, I mean, the whole thing was slimy and sleazy, and we don't like it, but did Trump actually commit these particular crimes? Maybe not.
Well, I think it's also the problem of the fact that the federal charges on fraud were not pursued earlier, right? I mean, this is basically working backwards from a mistake that was made previously, because I think they could have made a much broader case about Trump's criminality as a fraudster, as someone who cooks the books internally, and then also like to banks and to the government, if the civil fraud cases were within the scope of a criminal case. But that's not how things shook out. I mean, maybe you can go over that history a little bit, Professor, but like this piece of fraudulent behavior, or alleged fraudulent behavior, I think could have been a much stronger case, obviously, if it was presented in tandem with the other fraudulent activity.
Yeah, I mean, it's always hard to tell from outside of a criminal investigation all the reasons that went into those decisions, because we usually only know a pretty small percentage of the relevant information, because most of it is secret grand jury. So there were certainly a lot of suggestions floating around of a broader possible criminal fraud case, that would have included Trump himself. I know one of the counter arguments to that was there was no actual dollar loss in these frauds. And so for criminal purposes, often that's not a good criminal case. I mean, they brought the civil fraud case, but there was really not much evidence that the victims lost any money. The banks all got repaid and things like that. So factors like that enter into it. Would have been similar issues about proving Trump's personal knowledge, again, in a criminal case versus that of his attorneys and things like that. But it's hard to say from the outside why they backed away from the larger fraud case. It certainly did look like it had some potential appeal as a larger criminal case, like you said.
So, what are the possible outcomes that we could? I mean, who knows how long the jury's going to deliberate? I mean, theoretically, right? They could be they come out with a verdict this afternoon. But what are the potential outcomes?
Yeah, I would, like you said, it's impossible to say. It'd be really unlikely to come back today, I think. I would expect with this number of charges and kind of the gravity of the case overall, you'd expect them to take a couple of days, at least. But so possible outcomes are finding of guilty on all 34 counts, an acquittal on all 34 counts, a split, guilty on some counts, not guilty on others, or a hung jury where they're hopelessly deadlocked and they can't reach a verdict on any of the counts. Or conviction on some counts and hung jury on other counts. I mean, there's a lot of possible variations with 34 counts in play here.
And so, just to be remind people, the jury has to be unanimous on conviction of on any particular count. So you could theoretically have the jury unanimous on one count, and then hung jury, I guess, on 33, or acquitted on 33.
Yeah, it's possible. It doesn't seem all that likely in this case, given the facts. Since all the charges are so similar and the documents are so similar, it kind of feels like it'll be all or nothing.
If it's a hung jury, obviously, if he's acquitted, that's probably the end of the story for this case. If he is, if there's a hung jury, then what happens? Bragg makes a determination whether to bring this case again, but I mean, that seems, well, you tell me. It also seems unlikely that he would do this again.
No, the hung jury gives the DA the right to try the case again, and then, like you said, that's a decision that they make, kind of evaluating all the information they have about how they thought the case went. Was it a hung jury 11-1 for conviction, or was it 11-1 for acquittal? The factors like that. But pretty common to try again. Usually if you think your case was righteous in the beginning, that you thought it was appropriate to bring it at all, then you will try at least one more time if there's a hung jury to prove
Presumably
it again.
That would not resolve itself before the election, though. I
assume not. It could potentially. It'd be up to the judge and the DA how fast they wanted to reschedule it. It's certainly not impossible for it to happen again before November, but I guess I don't know really enough about New York practice to know how likely that is.
Okay, let's move to the documents cases. What is the next sort of like, I guess, likely case to be adjudicated that Trump is facing?
The most likely is the DC case based on the January 6th events. So the Jack Smith special counsel indictment based on the conspiracy to overturn the election, basically the January 6th allegations. That's the most likely of the remaining three, and the chances of that one going to trial before the election at this point are very slim, but it's still not impossible. But the other two, Georgia and Florida, look almost impossible at this point to get to trial this year.
The Florida case in particular, right? Because Judge Aileen Cannon is giving a hearing essentially to every claim that's made to slow walk it so that it doesn't happen before the election.
Yeah, that's been an extremely frustrating case to watch. It's a real failure of the system. That the judge, if you put a judge in place, or if the judge is on the case, that is determined to sort of slow walk it, there's very little that the prosecution can do to counter that. And, this is a case that before a more experienced, impartial judge would have been to trial by now already. It's not a complicated case. But because of the amount of time she's taking to resolve every tiny little issue, as you know, she's now postponed the trial date indefinitely. We don't even have a trial date set in Florida, and just no way it's going to happen this year the way it's proceeding.
Is that inexperience or is it impartiality?
Well, it's hard to judge for certain from outside. I mean, and so I'm a little reluctant to assume bad motives, but it's it could be a combination of experience, incompetence, and being partial to Trump, trying to deliberately tip the scales. And which one of those you think it is, or in what proportion, there's a lot of varying views, but I think there is pretty universal opinion that it's been inexcusably slow.
Is there
for whatever combination of reasons? Yeah.
Is there no mechanism for the prosecution to basically circumvent Cannon and say, go to the appellate court and say, something's amiss here?
There is. They can go to the 11th Circuit for what's called a writ of mandamus, like an order from the 11th Circuit to order her to act in a certain way. And when they do that, they can ask the Court of Appeals to reassign it to a different judge. That's a really extreme remedy that doesn't happen very often. And one of the frustrations about what's been going on here is that Cannon's been, again, whether through luck or deliberately, kind of avoided issuing the kinds of orders that might lead to that, because it's just been scheduling stuff. It's just been, take the time she's going to take to consider motions and then sitting on motions for months before deciding them. But she's not issuing the kind of, really clearly legally wrong adverse rulings that then might justify the special counsel to take her up to the 11th Circuit and say, by the way, she's demonstrated this pattern of, bias on the case, improper ruling. You really should remove her. He doesn't want to do that until he's got a really compelling case for it, because he's probably only going to get one shot at that.
Right.
You don't want to strike the king and miss, right? And she hasn't really given him yet the footing to do that, right? The kind of ruling that might allow him to do that.
Do you think that she would have? Do you think that's dumb luck, or do you think that, or do you think she has a savvy that maybe we don't know of, or do you think that it's possible that she's got access to other people's savvy about avoiding that tripwire that might have the 11th Circuit say, okay, now we have something substantial in which we can act upon?
Yeah, I mean, I guess any of those are possible. I don't know how we would know, right?
Right. Well, I mean, I guess I also am curious too about, Trump wins, right? If you could just reiterate to our audience what would happen to these two Jack Smith cases, and what the future would be, and why it's so important for Trump that the two federal cases right now are being delayed.
Right. I mean, that's what's been so frustrating about the whole thing. We're in a unique situation where a criminal defendant is potentially going to be in a position to cancel his own prosecution. I mean, that has never happened before. And that was one of the arguments for urging the Supreme Court to act really quickly on the immunity question. People suggested, it seems kind of improper to ask them to keep the election, keep the political calendar in mind when they're deciding. Why should they speed it up just because the election's coming? Well, the answer is there's never been a case like this before, where if the defendant wins the election, he can cancel his own prosecution. So this needs to get resolved before he potentially has that power. The people have a right to have these charges tried, and we can't just assume it'll happen in 2025 if he wins the election. So yeah, if he wins, he will have the power as head of the executive branch to order the Justice Department to drop the cases, the federal cases, and that you'd expect almost certainly will happen. He could try to pardon himself. That's untested, and may become unnecessary if he just drops the cases. Unclear, the effect on the state cases would be less clear. I mean, certainly if the New York case, if he's convicted, there won't be much of anything he can do about that at that point. He might be able to get the Georgia case at least put on hold. I think there'd probably be a pretty persuasive argument that a state can't criminally prosecute a sitting U.S. president while they're in office. So maybe that gets, at a minimum, delayed for another 4 years. So he can definitely do a lot to thwart his own prosecutions if he wins re-election, and that's one reason it was so important to try to get these resolved before that took place.
Just getting back to the January 6th case in D.C., which appears to be the only one with any serious potential of having, resolution prior to that. What, just give us the contours of that, and what would have to be proved, and what the charge, what he could be convicted of, I guess.
So there's four main charges. There's a conspiracy to defraud the government, which is basically a conspiracy to interfere with the lawful functions of the federal government. In this case, a conspiracy to thwart the legal counting of the ballots on January 6th, right? That everything that happened leading up to January 6th with Trump and his unindicted co-conspirators and others was part of a plot to thwart that government function where they certify the election on January 6th. So that's conspiracy to defraud the government. There are two charges related to obstruction of the congressional proceeding, which is, again, very similar, trying to thwart Congress from counting the ballots properly, or send false information to Congress in the forms of phony electors and things like that. And then a conspiracy to violate civil rights, which is to deprive people of their right to vote by taking the votes of citizens in those 7 states where they came up with this phony electors scheme, and trying to have their votes basically thrown out or not counted. So all the counts are basically based on the same set of facts. It's the entire scheme between the election and January 6th that used different mechanisms: the phony electors, the pressuring state officials, the pressuring of Mike Pence, the calling testifying falsely before various state proceedings about supposed election fraud that didn't happen. All these different steps combined are part of this scheme to overturn the election and thwart Congress on January 6th. So that's the real, to me, has always been the most important case, the most fundamental one, really about the assault on democracy itself. I mean, the classified documents case is important, but it's not in the same category to me as this one, this really fundamental assault on democracy, fighting the peaceful transfer of power, trying to overturn the election results. That's the most significant case. And Georgia is based on the same allegations, basically. But the DC federal case is better chance of getting to trial.
Is that DC federal case, I mean, what do you need to establish here for a conspiracy? Because my understanding of a conspiracy charge is that you don't necessarily need a lot of I guess, huddling between the different members of this conspiracy. But what you need them to do is all be acting in a manner that is sort of somewhat in concert to commit this crime of interfering with the normal function of the U.S. government. So if Donald Trump sends Rudy Giuliani to file a court case on in one state, that is at least in part evidence of a conspiracy. Is that right? And how much does it play into it that, like, in Arizona, let's say, if Rudy Giuliani is found guilty of a fake elector in Arizona, how much of that is, implicates Donald Trump?
Yeah, so it all, the heart of a conspiracy, any conspiracy charge, is the agreement, right? So what you have to show is the agreement among the defendant and co-conspirators, whether they're charged or not, to commit a certain offense. Now, they don't have to succeed, which is kind of the beauty of a conspiracy charge, right? So obviously they didn't succeed in overturning the election, but that doesn't matter for a conspiracy. It's the agreement, the criminal, undertaking, the joint undertaking together. And once you're in that agreement, then the conspirators are responsible for what their co-conspirators do, right? So once they've formed this agreement between the president, Giuliani, and Mark Meadows, and all the others that were allegedly involved, then if Rudy Giuliani goes to Arizona and pushes a fake elector scheme, all the other co-conspirators are responsible for that. The partners in crime are responsible for each other's actions. So then the tricky part, like you suggested, is proving the agreement, right? Because can Donald Trump just kind of sit back and, well, I was just sitting in the White House and these people were off doing things on their own? Not unlike the defense in the New York case that just concluded, right? I mean, part of the suggestion is Cohen and Michael Cohen and Alan Weisselberg and others were just cooking this up on their own, and Trump wasn't really involved. And especially when you've got someone who famously doesn't use email, doesn't like to create a paper trail, proving that he was part of the agreement can be challenging. But I don't think it would be too difficult in this case. I think there's going to be enough evidence of these Oval Office meetings and things like that, where all these different schemes were cooked up. And, agreements are often proven by circumstantial evidence, right? Meaning, the example I would like to use for my students is, if you and I get in a car together, put ski masks over our head, go into a bank together, rob the bank with guns, and drive away together in a getaway car, what are the chances that that was all just a big coincidence? Right? Zero, right? Obviously, we had an agreement to rob the bank. But you can ask a jury to find that agreement existed. We had a conspiracy to rob the bank, even if neither one of us testifies that we ever sat down and made this agreement. The agreement can be inferred by their actions, and that's sort of what the government would do here. And
there's a recording. The agreement, yes, has to be proven, right? But there's a recording of Donald Trump saying, "I need you to find," I forget how many votes it was, but
11,700. Yeah. And that's only one very small part of the case. But yeah, I mean, there's plenty of evidence like that, recordings or emails back and forth between other people, or Oval Office meetings, like I said, where these various plots were hatched out, things like that. I think the evidence of the January 6th case is very compelling. It just they just have to be able to get it in front of a jury.
What is the biggest impediment right now to this case starting in earnest, I guess?
The Supreme Court. The whole thing has been on hold for months while we wait for the Supreme Court to rule on the claim of presidential immunity. And it can't proceed until that's resolved. They could have taken it quickly. They could have acted much more quickly than they have, and they didn't. And so now we're all just waiting to see, are they going to at least fast track it and maybe decide it in May, or, I guess May is almost over, but maybe, before the end of the term? Are they going to wait until the very final day of the term? The longer it takes the Supreme Court to act, the harder it is for Judge Chutkan in D.C. to then get the case sent back to her, resolve any remaining questions that the Supreme Court opinion might raise about, do I have to decide whether some particular acts in this indictment maybe can't come into evidence due to immunity, whatever, and then go forward with the trial. But she has said in the past that once the case comes back to her, she's going to give Trump about 3 months to get ready for trial, because that's how much time was remaining before her original trial date when everything got paused. So she's basically
can I guess
this isn't binding, this is what she's said. What's that?
Can I guess when the Supreme Court is going to come out with their ruling in that case? Or let me rephrase it this way, because I do ask this question of all law professors that I've had on the program. We've had a lot, but I'll ask it in a slightly different way. To use your example that you give your students about the ski masks, do you think it's a coincidence that in this instance the Supreme Court is taking this long to address this this question of presidential immunity, where we have seen shadow docket after shadow docket after, like, it was so many other cases where they are able to move rapidly? I'm old enough to remember the 2000 election. Do you think, I mean, are we in a two people are getting into a ski mask in a car type of scenario here, or what?
I think probably every justice on there has a different view of what their appropriate role should or shouldn't be here. I don't think there's a criminal conspiracy going on. I do think there are some on the court who aren't in any hurry to push this. We've seen some controversial stories about, some members of the court recently, and their actions that might suggest a certain sympathy to a lot of what went on here.
Yeah, I think that's safe to say.
Yeah. I think to me, again, you're always trying to read tea leaves from the outside. I think it's fairly likely that quite a few members of the court would feel like, look, the timeline isn't our fault, right? This case got to us when it got to us. We don't normally take political calendars into account when we decide our cases. And so if it took until now for this case to get to us, whether it gets resolved before the election or not is not really our problem. It's not a legal problem. And so it's inappropriate for you to ask us to speed things up. We'll just handle this in ordinary course. Yeah.
We have you just for a short time, so let me ask you about this scenario. If this is the doomsday scenario that I'm hearing, I mean, from our perspective, that they say that now we're going to send it back down to the lower court where they can determine if it's an official act, and they will take their time to deliberate on that and then send it back. And then we can make an assessment, I guess, about what constitutes an official act as the president or something where he's in acting in his personal capacity. If that happens, does that affect the timeline of the trial as well? Because then the circuit court has to make that separate determination.
Well, I think a whole lot depends on what the Supreme Court says and how exactly they say it, right? Because you could see them deciding this case in a way where basically it's done for purposes of this case and there's nothing left for the trial judge to do and they can just go forward. Or you could see them deciding it where they say, okay, well, now we're announcing this new 5-part test to decide whether certain acts deserve presidential immunity, and now you trial judge have to resolve that. And that could take some time, but on the other hand, it may not take a lot of time, right? I mean, I don't think it's a terribly complicated question about whether most of the acts in this indictment, assuming they announce something reasonable in terms of what's the scope of possible executive immunity, core executive branch function, ordering troops into battle, that kind of thing, that none of this applies to this case, and maybe Judge Shuckman could resolve that fairly quickly, but it absolutely affects it, because if they give her more work to do, then that's more time she needs to spend before she can get the case to trial. Now, maybe it could be done really quickly and she could still stay within that 90-day window, maybe not. I don't think there would be more appeals back up to the Supreme Court at that point, because now we're just talking about ruling on particular pieces of evidence. It's no longer a ruling about whether you can avoid trial altogether. And so if you analogize it to something like the speech or debate clause, at that point, you can object and you can appeal after conviction with all the other evidentiary issues that come up at trial, but you don't get to go running back to the Supreme Court every single time there's a ruling on immunity.
It's not a question of law, it's a question of facts at that point.
Yeah, exactly.
Professor Randall Eliason, white-collar crime professor at GW Law School, author of the Sidebars newsletter. Thanks so much for your time today. Really appreciate it.
My pleasure.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.